Good evening to you all. My name is Sristi and I'm a member of the United Forum for Legal Studies. The team and I are delighted to welcome you to the first webinar that we have hosted. And today we'll be understanding about the Narcotics and Psychotropic Substances Act, the NDPS Act of 1985, its intricacies and the varied nuances that surround it. After all, it is an extremely burning issue in today's time that demands a good understanding. We are honored to have with us two brilliant gentlemen who will be addressing the issues at length and will only help us in understanding them really well. I'd like to welcome Mr. Nitish Rana, sir, as he's here with us at the moment. He's an advocate at the Supreme Court of India and is also the standing counsel for the Enforcement Directorate, Ministry of Finance. And he has been fighting for some really high-profile cases as well. We welcome you, sir. Both the speakers are also the honorary members of the UFLS, and they have been of incredible support throughout to the team, and they've been really gracious to be available throughout for even the tiny little queries that we have had so far. So I think without any further ado, I would begin off the session, and I'd come to Mr. Rana and ask him to throw some light on the history of this act and the developments that have taken place over these years, because it's extremely important for us to understand the substantive portion of the law itself in order to connect it with everything else. And then maybe we can touch upon the provisions of bail that are covered in the act. So over to you, sir.
Hi everyone, I'm Nitish Rana here. I will just, though there are very short time of 15-20 minutes, I will try to give you as much possible about NDPS, as it is a burning issue. As Sristi has said, that whole country is talking about NDPS, and probably Sushant Singh's connected with this act. So therefore I will, as a lawyer, it's a different than what people talk or news talk. So we are talking here as a lawyer. We have to go by the law, not as a public perception, what people talk on television, what they discuss. Sometimes I laugh on them, what they discuss. Nevertheless, let's start with the NDPS Act. See, NDPS Act, first you understand what is the need of NDPS or drug laws in our society. Let's understand. See, drugs has been a menace for the society. It's the biggest enemy for the society for decades and decades. Even in the history, if you go by the history, US used to be one of those places, very renowned places are there where all those drug mafia used to stay. So for the decades, centuries, drugs has been a major issue worldwide, not for only our societies. So, you know, in 1857, there was a act was enacted by the Britishers that was called Opium Act, under which all these prohibited substance were being controlled. Thereafter, again, this act was a fresh act was brought, Opium Act 1978, and that this issue was being controlled under those this act, Opium Act 1978. Eventually government of India and the Britishers together again brought another act called Dangerous Drugs Act 1930. That was another, you see, you know, after so much of legislation, 3-4 legislation, all of us can understand what was the, why these are the like a very much need for the society to deal with the drugs issue. And you know, all these 3 acts, even for like decades and centuries, could not be adequate to deal with this situation, because this was deep rooted in the society for centuries, even if the ancient time you go. So ultimately government of India realized in 1985, considering the menace in the society, to enact a new laws, and that is where NDPS in 1985 was enacted, with the certain provisions and everything. But subsequently, as per the experience after 1985, that law, the provisions of 1985 Act was also not sufficient to deal with the situation, because this was increasing day by day. So eventually this Act, 1985 NDPS Act, went into a couple of amendments, and finally in 2001 there was an amendment which we are right now applying all over, which is quite stringent. So this is what is the little history about Drugs Act. Earlier there was Opium Act 1857, then 1878, then Dangerous Drugs Act, and then eventually we have now NDPS Act in 1985. Let's understand why we need, why drugs is such a big menace for the society. See, when the drugs comes to the society, first you weakens the structure of the society in a way that our young generation goes into it, get addicted, and our manpower is totally devastated by the drugs. Then the drugs money goes into terrorism. It increases the inflation. Then it goes into it gives rise to the crime, corruptions. All of us, every individual of the society is affected by the drugs directly or indirectly, because the drugs money, once it comes into the market, see, so we as a legitimate businessman, legitimate serviceman, we earn some money, but then see the illicit money or the dirty money which is being earned through drugs comes into the market. It gives rise to the inflation. Then things become very expensive. As a legitimate person, if the things which you want to buy a property for, let's take it 50 lakhs rupees, person who has got a illicit money, he can buy the same property for 1 crore rupees, because he doesn't care for the money, because he has got a illicit money. So indirectly entire society is getting affected with this drugs money, and that is where it is menace. Now this was a little history. Probably Mr. Arif will come and give you how society is majorly affected, because they are dealing onto the ground level. I'm just telling you how briefly about it. Now I'll take you to the rather in the law, then the more on the social aspects of it. See, drugs laws, there are 4 laws. All of us have seen it, whether it's the NDPS Act, whether the Prevention of Money Laundering Act, whether it's a MACOCA, or it is a UAPA. That's a unlawful activities prevention act. All these acts, earlier there was a POTA, then there was a TADA. So all these 4-5 acts, if you open all books together, you'll find the bail conditions and the offenses are made very stringent. And all these acts have a similar, stringent condition for bail, because directly, these offenses falling under these 4-5 act are a very, very serious offenses. There's a heinous offenses have been considered by the government, society, and the Supreme Court. That is why these 4 acts right now in existence, we have Prevention of Money Laundering Act, NDPS, UAPA, and MACOCA. All these has a more or less very similar provisions on bail. Let's come now directly to the why drugs, what makes drugs offense. There has to be some provision whereby drugs has made offense by the law. See, if you go by this chapter 3 of the NDPS Act and section 8, which makes these substances, these narcotic substances, whether it's a poppy seeds, cultivation of opium, cannabis, ganjas, and all these things, this section 8 makes it an offense. It prohibits, it restricts, it controls the entire system of it. So see, the government has an indirect control over this. Government do whatever. The government is giving licenses to some of the farmers to cultivate opium, but it is restricted. That is in a very controlled environment. It cannot be given into the market. Government purchase it for the purpose of drugs, in the sense medicines and all. So government has a control over it, and it prohibits for people to trade into it, make money out of it. So all these laws. So section 8 chapter 3 makes the NDPS, that's a drugs in different form, is the poppy seeds, as I said, or cannabis, whether it's with a coca, all these are offense. And then the moment you in between, I see Mr. Arif has joined. He's on the phone. Let's continue with it. All right. So so that makes it offense. Then if you go to once you see the section 8 of the act, which makes the drugs and these narcotic drugs an offense, and it prohibits, then you move into the chapter 4, where you see the penalties. Now, chapter 3 and 4 are very, very important as a lawyer's perspective, as a students of law perspective, where you find what is the offense and what are the penalties. There we are more concerned with that. So if you move to the chapter 4, where you'll find section 15 onwards, that, the punishment for different substances. If you go into the act, you will find drugs. Drugs means there is not one particular kind of drugs. They are multifarious. There are many things. It can be cannabis, it can be poppy, it can be opium. There are many things if you go into that. So there is a punishment for decided for everything, all those, either opium, cannabis, all these contrabands under chapter 4 and 15. Now here I'll give a little classification of it. See, if you see, there are 3 categories of government notification has by the gazette notification, it has been decided. There are 3 types of 3 quantities, basically we can say. One is called a small quantity, another is called intermediate, which is a little more than small quantity, and then it comes to the commercial quantity. So punishment for all these quantities have been decided differently. Let's take it for the small quantity. You will see the punishment is less than 1 year. Why I'm saying mentioning the punishment, I'll tell you why this is important to mention here right now. Punishment 1 year. So if you go into the second category, which is the intermediate category, punishment is less than 10 years. Then if you go to the commercial quantity, their punishment, minimum punishment is fixed 10 years. A maximum goes to 20 years, and then it can go up to the death also in the subsequent, offense. So this is how it is categorized, the offense according to the quantities which is recovered from the offenders. So all these, and if you go by the opium or it's a cannabis, coca, etc. So everything more or less you'll have the punishment, a similar punishment in it. Now coming to the the most important chapter is the penalties over this. So suppose, let's take it. This is a section 27A is a very, very important section, and 19 and 24. See, if you go into all these sections 19, 24 and 27A, you will find here it is not the consumer. These sections relates to the people who are dealing into the drugs. They can be preserving it, they can be manufacturing it, they can be trading it, they can be harboring, they can be financing, they can be warehousing it. So 3 section 19, 24 and 27A makes a very important provision in the NDPS, and accordingly punishment has been decided under 37, where bail and everything is there. When I'll come to that section, I'll tell you. So what is the government intention was that by making trade in drugs more stringent, was that let's break down, let's nip in the bud this drugs entire menace by breaking the backbone of the trade only. That is why such stringent harsh punishment has been the provision for NDPS for all these traders, manufacturer, financer, harbors, etc., who stores it, who promotes it, who conspires it, who brings to the country, who exports it. So all this is where, so 19, 24 and 27, it deals with these things. Now and then there are other things like small quantities or intermediate quantities, where punishment are lesser, and the bail is also not stringent conditions are not applicable to those small quantities or intermediate quantities, who are in a possession of it. So once you are in either in the possession of the commercial quantity of the drugs, any of the substance which is mentioned in the Gazette notification, or if you are falling under the category section 19 or 24 or 27A, which relates to the trade, directly it's related to the trade in terms of anything, finance, harboring, as I said, and all those, etc. So if you're relating to these any of these categories, then section 37 is a very, very serious for you. Now I'll move on to the section 37. I was explaining you the offense of NDPS. Now let's go into the section 37, where it makes the offense under NDPS cognizable and non-bailable. See, here you have to understand one thing. If you go into the CRPC, where it says that the offense which has a punishment less than 3 years makes a bailable offense. But in case of NDPS, even punishment is a less than a year, still it is a non-bailable offense. It does not fall under the category of bailable offense. So therefore, all the bail applications has to be filed, and those has to be dealt in accordance with Section 37 of NDPS Act. Now, NDPS Act had two parts of it. See, one part is, as I said, that the entire offense of NDPS makes the, whether it's smallest, whether it's a commercial, small, minor, bigger, all offenses are cognizable offense. There is no non-cognizable provisions in NDPS. Second part of it is that even if punishment is lesser than 3 years, the makes offense is non-bailable. This makes the entire provision of NDPS non-bailable. Now, all of you know that what is bailable and non-bailable means. All of you know that. I would not dwell into that since there are very short time. Now, let's come to Section 37. What makes, let's take it, how to deal with the offense which is falling under the categories of Section 19, 24 and 27A and commercial quantity. There the punishment is a lesser, whether it can be less than 7 years, less than 10 years, or less than 1 year in case of small quantity and intermediate quantities. So bail is easily granted to them, but then still it is a non-bailable. It cannot be as claimed as a matter of right. In bailable offenses, you know, the offender says it is a matter of right, and that's true that they get bail as a matter of right, but not in the case of, even it is punishment is 1 year or less than 1 year, it is not matter of right. So Section 37 says so. But if you come to 19, 24 and 27A and commercial quantity, now there are twin condition has been imposed on them, and that twin condition is a very stringent. What are those twin conditions? See, if offenses are falling under these four categories, Section 19, 24 and 27A or commercial quantity, all these you'll see, all these, a link between all these four types of offenses are, it relates to the trade. They are making profit out of it. They are infusing drugs into the society, and they are making money out of it, directly, indirectly. That is why these two serious twin condition has been imposed on them. What are those? When bail application comes to the court, the public prosecutor, I'm also the public special prosecutor for enforcement directorate, so I'll give you a lot of examples what happens in the court sometimes later when we have a lot of time. So public prosecutor will be called upon, and he will be asked to give the entire facts to the court. He'll get a chance to argue against this bail application and give the complete facts. This is one. Public prosecutor will get opportunity to oppose the bail application. That's one. It means what happens? You will say in all bail application it happens. Public prosecutor comes and oppose. This is something more than that. In other side, other laws, you will not find that it is specifically, it is written that the public prosecutor will get a opportunity to oppose the bail application under 439 CRPC. It is not written. So it is discretion to the court. Court may grant in absence of the public prosecutor. But in this case, in NDPS or in PMLA, that's money laundering, or this specifically Parliament has enacted, the legislature has said that public prosecutor, without his presence or without hearing him, bail cannot be decided. So the public prosecutor will come and give the entire picture of the offense. Entire investigation will be produced before the court. That's one part of it. Now the second condition is that this under second condition, judge has to give findings, and that is a sine qua non. It is a necessary to give the finding that the person is not guilty of the offense, and judge has to satisfy himself that once he's released on bail, he'll not go back and commit the similar offense again. Now you see the kind of stringent provision, how judge has to decide and how it has to come to a conclusion when the entire investigation material is before the judge to decide that this person is not guilty of offense. And secondly, how he will be sure that he will, once he is released on bail, he will not commit the similar offense. So this makes a very narrow, it's a bottleneck. The parliament, the legislature has given a very narrow path, a narrow space for the judge to grant a bail to the person or offenders who is involved in the NDPS Act. So this is where it makes it very, very stringent. Now, a couple of questions I'm sure I'll face it later. Before that, I'll just tell you. Now, you will tell me under provision 37, the twin condition, how judge has to give findings at this stage when the trial is yet to be taken place, that he is not guilty or he is a guilty of offense, so grant him bail. See, that is where the judge has to apply his mind. A judge has to have a reasonable belief that the amount of evidence, amount of investigation has been done, which says that this person may not be convicted after the end of the trial, or he may not be the involved in the offense. So that findings has to be somewhere has to be born in the mind of the judge by the going by the investigation file and the evidence. But at the same time, it is not the prima facie he will just flip the files and go through. He has to give a findings. He has to show the indulgence more than prima facie and less than the conviction, in somewhere in between, that he has to be satisfied that this person is not guilty of an offense. So little more than prima facie observation, and the less than the going into the entire appreciation of evidence and the elements, all those evidence collected by the investigation. Somewhere in between, he has to balance the strike the balance between those that this person may be acquitted after a couple of years, and that is where bail is granted. But then it is a very slim chance where people who are involved in these 4 categories of offense are getting bail. And the commercial quantities and 19, they are basically traders. They are basically making profit out of it. They are infusing drugs in the society. They are spoiling our young generation. They are spoiling the economic system of this country. They are breaking down the basic economy of this country by infusing the illicit dirty money. What I call is a dirty money. And that is where they give, market is totally, there's the old saying, some economic has said, the bad money drives out the good money. Now, see, society has to keep the economy intact. It has to be a proper structure. Good money has to be in the society. But when bad money comes, good money automatically goes out. I'll give you a very, very, simple example. Probably you understand. Let's take it. You go buy a property. Property is worth, let's take it 1 crore. You want to buy that property for 1 crore. And you are a legitimate businessman or a serviceman. But a person who has got this illicit money, who is earned through drugs, because that's not counting. It's all about illicit money, and it's in abundance. Doesn't matter for them where even if they pay for the same property 1 crore 50 lakhs or 2 crores, because their idea is not to buy the property. You will, as a legitimate man, you will go and buy the property. You want to be the consumer. You want to stay in that house, or you want to do the investment purpose. But person who has got the illicit money, their idea is not to do the investment or go be the end consumer. Their idea is that the money which is earned out of drugs, out of these illicit and illegal business, they want to legalize that money by infusing that money in the property. So that this money, which is illicit money or dirty money, will be streamlined over the period of time. That is their idea. So that is how they are giving a rise to the inflation, and they are weakening the economy of the country. Then when people are drugs addict, they go into the crime. Then these money, same thing, goes into the terrorism. They wage war against the country. Terrorism is funded through these monies. Since I'll give you a little example, because I am counsel for NIA, also National Investigating Agency, dealing with the UAPA, money laundering I am dealing with, then NDPS also. So this is where is the entire society is affected by this. Now, coming back to the law. So section 37 has 2 very important aspects. I'll come back to that again. This is financing and harboring. Now, what is the meaning of financing? Let's take it, assume it. 2 friends, A, B friends are there. B goes and buy a small quantity of drugs for A, who's a friend, and then B only pays to the dealer and buys that for consumption. Is that a financing? Financing charge will be imposed on B? No, because that is not financing. Here in section 37, financing strictly, if you see the entire, if you read collectively and you see the entire intention of the act, is the financing mean when you are financing the trade and making money out of it. That small money or paying for and buying for drugs for the consumption is not financing. So that will not be coming under the ambit of financing. This is what has happened. I'll mention it, what happened in Sushant's case, that the Riya Chakravarti used to buy drugs for Sushant, and that is where section 27A was imposed on her, which is not the correct way. Section 27 cannot be applicable on her. This is what Bombay High Court has also said, that she was not financing, she was buying it, she was purchasing, she was paying some for purchase. So that is not the financing. Financing is when is the larger picture you have to see. Financing means you are investing money and giving rise to the drugs business, drugs trade, and making profit out of it. So that is what is the financing means under provision of section 37. Now another aspect is a harboring. What harboring means? Harboring is equally stringent and equally offense as section 27 or 19 or 24 other offenses are there. Harboring means you are giving patronage to the drugs dealer, you are giving food, shelter, you are hiding these drugs dealers. So you will be coming under the ambit of section 27A, and the stringent condition, twin and stringent condition will be applicable on you. There are, I'll give you certain cases like a state of Punjab versus Baldev Singh, or you Stephen Muller. These are the landmark cases. Supreme Court has decided how to interpret NDPS Act. NDPS Act, if you go, if you read it in a very casual manner, it is little difficult act, little technical. So you have to understand carefully. You have to go into the judgments also to find out why even CRPC says that offenses which is less than 3 years are bailable offense, but then NDPS says no, it is a non-bailable offense. So all this is what is the category between CRPC and NDPS. Even if the stringent condition in less than 4 categories, as I said, 19, 23, and 24 and 27A commercial quantity. Other than these offenses, stringent twin condition will not apply. But then still it is non-bailable. If judge wants to give it to you bail, only then you'll get the bail. You can't claim as a matter of right. So therefore, part 2 of CRPC, which makes about 3 categories: bailable and non-bailable. I mean, to punishment which has offense which has punishment more than 3 years, less than 7 years, or less than 3 years. So above 2 has been made as a non-bailable, and less than 3 years has been made bailable under part 2 of CRPC, which has no relevance in the NDPS Act. So therefore you have to be all those who are involved into NDPS Act or NDPS offense has to be very go through a rigorous. These are the I always say these twin conditions are, and these are rigors or imposed on those offenders who commit this offense. Now coming to these second aspects of it, this is what is the little bit about offense and bail I was talking about. Now if you come to the other part of it, section 31 speaks about if all these offenses, all these 4 categories, keep in mind, very important, all these offenders of these four categories, if he commits a subsequent offense, second offense, and if it is convicted, it can go up to the death sentence. So there is a provision of death sentence also in the subsequent similar category of offense, and if you are convicted, death sentence will be awarded on them. And similarly, if second, let's take it in other categories, whether small categories or the intermediate categories where offense has been committed, so in subsequent offense, punishment will be doubled, or according to the it's like a triple so punishment increases in the subsequent offense. So death penalty is there in the NDPS Act also. Now one very important aspects which I love to read about NDPS is the reformative part of NDPS. See, even after all these stringent and laws and conditions on a bail and everything, Government of India or a parliament was quite aware about the fact that the drugs addictions are basically a social evil. A person, let's take it, a young boy, 15, 20 years, 22 years, gets addicted. If you go to Punjab, if you know other part of Punjab is highly affected state right now, where the drugs comes from Pakistan or maybe other part of the world. So if gets addicted, Government of India made a provision under section 64 and 71. That is where they give you pardon. If you are a consumer, you have to agree that you will go to the rehab. and you are ready for the reformation. The moment you surrender yourself for the reformation, reformative measures are there so that you'll get a pardon. They may not convict you at the end of the trial, because these are the basically, this is what I say is a reformative laws. So for the consumers who are the buyers, who is small quantity, who is addicts, for them there is a pardon provision if you surrender yourself for the rehab centers. Rehab centers has been created by the government of India. Now, second category, even for the people who are involved into 19, 24, 27, A or commercial quantity, even the government of India has a provision for pardoning them also, provided they come and give a complete disclosure. He comes disclose before the agency, before the court. These are the chains. This is where entire material used to come. This is how distributed, who all are involved. So this is what is called is, he is giving the entire picture so that it assists to the investigating agency to investigate further, break down the bone of this entire social evil. So that is where pardon is granted to the offenders. Then not only this, there in section 71, if you go, you will find government has to set up a rehab centers. Government has to set up a centers to identify a particular area. Let's take it in particular area. There are a lot of drugs infused, and the youngsters and the young people or old people are getting addicted to it. So government has to identify those areas, establish a center, control them, put them into rehab. And so these are the reformative structures, reformative measures has to be taken by the government. So it makes the law, it gives an impression that law has a reformative intention of the law. And to make this entire thing, reformative and everything, all these stringent, conditions have been put on those traders so that they will be staying away from these kind of business. So this is what, when I have done history honors in Delhi University. I'm from St. Stephen's College, actually. So I was reading American history there. So, in those times, you see, like centuries before, there is a place called Chicago. All of you are aware of it. Chicago was supposed to be called the mafia city, mafia state, where the drugs, arms, and all those people used to stay in Chicago, and Chicago used to supply drugs to entire world. So you can understand from 1800 onwards, drugs has been a major issue for the society, and we have to stay away from these menace, and we have to keep our people stay from this. And somehow there is a Mr. Arif, I think he's already there. Police roles and the lawyer's role comes very important in this. So as a lawyer, I say, as a lawyer, you are not here to do the profession only. You are the watchdog of the society. You have to take care anything which is happening in the society, and this is your moral responsibility. This is why it is not only called a profession, it is called a noble profession. So anywhere it is happening, anything is bad happening, anywhere you find these kind of things, bring it to the notice of the police investigating agency or a court, take action on it, save the country, save the society. Now I'll take a questions, or let Mr. Arif address, so that we can take question in the end, whatever way moderator decides. Anything else?
That was really, really nice, and a really brilliant session, I must say, on behalf of you, sir. And I'm sure that everybody enjoyed it. Thank you so much for sharing with us. And you spoke really passionately about the whole reformative theory and the reformative provisions of the section of the Act that you mentioned. And I think somewhere the Act also gives us hope that there is a reformation theory that is involved here, and it's a very brilliant way that you have explained. Absolutely. And I think we would now move on to Mr. Arif Sheikh, so that sir can also explain his views and say something and address the students. We are again delighted to welcome Mr. Arif Sheikh, Deputy Inspector General of Police, Raipur. And he's also the director of the State Anti-Corruption Bureau and Economic Offences Wing. He has been actively involved in taking measures to prevent corruption and in investigating serious economic offences in the state of Chhattisgarh. A very, very warm welcome to you, sir. I would request you to please address the viewers now and maybe briefly explain to us about the difference between the pharmaceutical drugs and the narcotic drugs, as there is no such distinction that has been provided in the Act, and maybe just touch upon these sections of sections of 35, which make the relevance of mens rea or the guilty mind in such offenses. I also need to tell you that Mr. Sheikh was very keen on sharing with us about the preventive measures that are taken on way of controlling the drug abuse and addiction, and he was very interested in sharing such insights with us. So without further ado, I think I would request you, sir, to please address the viewers. We have one waiting.
So
Yes.
what I would ask is, like, if they can ask me any questions pertaining to policing, like any doubts as such about the actions of police, I would be more than happy to answer that, because I
luckily we had a couple of questions prior with the session, and I think they must be posed to you because they are particularly in the area of domain where you work.
I overheard one of your questions, like you were interested in asking whether marijuana should be legalized or not.
Yes,
so,
and
like I
apparently
would
there
like
were a
to
couple of questions related to that, so we would love to know your views,
I would
please.
like to contribute to that.
Sure,
See, initially, see, like marijuana or cannabis, it is somehow like closely linked to India's culture as such. It finds its reference in Vedas also. And as we all know that Lord Shiva, the worshippers of Lord Shiva, they also like offerings is made in the form of cannabis to him. So it has got some connection between religion as well as spiritual connection is there. So like before the commencement of this act, NDPS Act in 1985, ganja was legalized in India. Like there was no prohibition as such for any of the products of ganja, like ganja, bhang, or whatever. Okay. So initially, when the single convention of narcotic substances, India becomes signatory to it, but India, citing its cultural references, told that we will not immediately ban it. So 25 years extension, like it was given for India, so that they can enact an act pertaining to it later on. But to tell you the truth, the origin of this entire act somehow lies in the pressure tactics of United States. United States succumbed to the tobacco lobby. Okay. The tobacco lobby pressurized United States so that they ban cannabis across the whole world. And this act was passed only because of it. If you can Google it, you can find it out that what transpired exactly when this act was passed. But nevertheless, like ganja or bhang for that matter, though it is not explicitly mentioned in the NDPS Act that it is something illicit or banned, but its usage, it continues, and especially when we do enforcement pertaining to ganja or cannabis, chota quantities, minor quantities of ganja, normally small vendors or peddlers, they sell packets of 2-3 grams, 10 grams. Okay. And courts take very lenient view. Okay. And if we take action against them, but then also a court like gives them bail within the same day, or within 2-3 days they give bail to the peddlers. So it becomes all the more difficult for the police to do enforcement. Because see, if you read NDPS Act, there is 3 types of offenses depending upon the quantity. NDPS Act does not distinguish between the types, whether it is narcotics, whether it is psychotropics, or whether it is a controlled substance. Nowadays, new designer drugs have also come. NDPS Act is very silent on everything. What it understands, it's the quantity. It should be a small quantity, or it should be a commercial quantity. And the third one is any quantity which is in between the small quantity and commercial quantity. So this creates the gray area, and which is beneficial to the offenders. Okay. Like Mr. Rana has already told us that any consecutive offenses which they are booked in, the quantum of punishment or the whatever saza jo hai, it increases correspondingly. Like it will be for the initial conviction, it will be say 5 years. The next conviction, it for the same offenses, it increases by 1.5 years. Not exactly 2, it is 1.5 years. And there was a death penalty, but it has been now converted, like no longer death penalty, but 30 years of maximum imprisonment that has been prescribed by the Supreme Court in various of its judgment. So this is the overall story of the legalizing. But to tell you, one private member, one MP in Lok Sabha, he has one bill is pending. He has presented one bill to legalize cannabis. Okay. And it is in the motion. So God knows it will be legalized soon. Okay. So this is the whole story.
That is great, sir. That is great. Thank you so much for that. We have another question lined up for you, and if you'll be willing to take that.
Yeah.
So this question is again particularly concerning your domain of expertise. The question says, how is the illegal trafficking of drug in the state of Chhattisgarh being monitored? And what are the steps being taken to keep a watch on this and to overcome it?
See, like the most important handicap which Chhattisgarh police faces is that the drug, the cannabis or narcotics, whatever drugs which comes to the Chhattisgarh, so far we were not able to reach to the destination from where that drug has been procured. Like end-to-end chain has not been caught. So that is a big handicap, which actually I don't know why it has happened, but so far we were not able to do so. But for example, if I'll cite you one example, when I was SP Balod, at that time we had confiscated one truck containing about 1 ton of ganja, and in that we were able to expose the entire chain. Okay. But nevertheless, I believe the entire end-to-end chain could not be caught. And that is because big players, they seldom come into picture. Small peddlers, okay, they only get back to you. Okay. If Mr. Rana can please explain, some call is coming.
Some questions. Let ask whatever questions is for me. Laws relating to NDPS. Mr. Arif would give you some practical difficulties. Definitely, police has a lot of practical difficulties. See, it is not actually, you know, the drugs offense is not like one of those offense you go and immediately catch the offender or recover the weapon, gun or lathi, whatever. It is such a systematically, it has been organized throughout the centuries. So it is not that easy to break down the this chain has been, you know, very strong and very clandestine. So people, let's take it, will be sitting somewhere in Singapore or somewhere in Hong Kong, and he'll be dealing in drugs in Bombay. So it's very difficult, but then entire United Nations, entire international community coming together, they're trying their level best. That is why subsequently in 2002, if you see this Money Laundering Act, the basic idea to bring money laundering legislation was to break the chain of the money which is coming from the drugs. And I forgot to mention it, even the government and the parliament has gone to the extent to make, if any money which is earned, which is the generated out of the drugs business, it is a proceeds of crime, and if it is invested anywhere, that property is attached, the property is confiscated. But even though it's a big challenge before us, and we are still in the process to eradicate the entire drugs which is available in the society. So let's see, we'll go by that.
Of course, there's some hope to control the whole thing at the moment, and I'm sure that the people are going to just look into it, and possibly we'll be coming after some solution very, very soon.
In fact, if I'll give you certain example. If you go to Delhi, and especially as Mr. Arif said, some all these bawas. Well, I am not very much into it. All these bawas, and most of are committing crime and becoming bawas. So this is a little controversial statement, but then I give this statement openly. So all these bawa consumes ganja or contraventions and all, and they say this is a Shankar Ji ka prasad and all. See, let's not get into all those aspects. Today it is illegal, and that's illegal. As far as legalizing these things, it cannot be legalized in a totality. It has to be controlled. it can be given to the people who needs it for the medicines purpose or otherwise. But making it available abundantly in the cafeteria or in the market will spoil the young generation anyway. Young generations are too much addicted right now. So probably I would be against legalization. It can be controlled or restricted, not completely prohibited or completely open to the market. Cannot be left to that.
Of course, of course. There's another question lined up for you, which I saw in the chat box. And I think I should pose it to you, Mr. Rana,
Please.
first. Because, so I think this question says that Section 37 of the NDPS Act lays down the twin conditions for granting bail, which are similar to the twin conditions given under Section 45 of the Prevention of Money Laundering Act.
Money Laundering Act, yes.
Since the twin conditions of the latter act were declared unconstitutional in the Nikesh Tarachand Shah versus the Union of India case, as they were violative of Article 21, aren't the twin conditions of NDPS Act also violative of Article 21? And I think that's a very good question.
Very good question. Let me answer you very nicely. Probably under the go by the Prevention of Money Laundering Act. There was some anomaly in the Section 45 wordings, if some people would, if you have two acts, act before 18 and act before after the amendment, you'll find it. So the twin condition was struck down by the Supreme Court on a ground that bare reading of Section 45, it was taking back to the schedule offense for the purpose of punishment. So Supreme Court and its a bench of Justice Nariman had said that, see, you were not concentrating on your own act, that the offense under this act, you were saying in the provision of Section 45, the offense relating to the schedule offense. So it is taking back to the schedule offense. So rather than you should have worded it like that, the offense under this act. So that is why these two twin condition was struck down. That was the only classification aspects was struck down on that ground, because what it says that 3 years punishment, as I mentioned, 3 years punishment requires a bail to be granted. But the stringent condition in Money Laundering Act, bail was not given to the accused even for 5 years. I see a lot of accused are there for 5 years, 3 years, 4 years, are still in the jail. They are not getting bail. So the twin condition was struck down only on the basis of the arbitrariness and the classification that the wording of the Section 45, it was said that the offense relating to the schedule offense, it means it is going back to the scheduled offense rather than Money Laundering Act. So later what had happened, the Parliament had amended it and said the offense under this act, and this twin condition has been brought back. So in 2018 amendment, these twin condition after the struck down, it has come back and it is being followed by the courts. But then matter is still this twin condition has also been challenged whether it can be brought back to the act or not. But this is basically pending before the Supreme Court. But that right now we are following the fact that twin condition has been brought back by certain anomalies which was pointed out by the Supreme Court, and those anomalies have been eradicated, that's been taken away, and then it has brought back as a fresh. So those twin condition has been back to the Prevention of Money Laundering Act. And as far as if that has gone, this will whether this will exist or not, of course this will exist. As I said, that has been brought back. And secondly, if that is gone, does not mean this will go unless Supreme Court specifically strike down these two twin condition of NDPS Act also. So this has to be struck down, particularly going by the NDPS laws. So that's the situation.
It was a very interesting question that she had posed.
That was a good question. So I think that was a good question. Probably I think whoever asked the question must be satisfied with the fact what I said.
Of course. And I really like the way, and I really admire the way that you have been teaching us really passionately about everything. I think that's very commendable.
Passion for me. I love the profession, and that's why I'm here. Anything regarding to a law and lawyers, I'm always there. Anything else?
There happens to be another question that I think people would be very interested to know the views from you. How can drug abuse be mitigated or controlled among the younger generation? And I think it's very, very important question again, coming from, people like you who have been handling the legal fraternity. And
let's take it now. The probably a young generation should be rather more busy with the WhatsApp, Facebook, and the social media than the drugs. This is also one form of addiction. So I hope this will help this way, that way. Nevertheless, jokes apart, see, end of the day, we have to, our family has to give a good values. They have to tell in the beginning only that look, what is bad, what is good, what is going to be have a bad repercussions. So it starts from the family. If family gives a good value and all, tell them constantly this is bad, don't get into this. Apart from that, not only telling won't be sufficient. Apart from that, you have to keep watch on the child means, see, if person is 25 years old, you can't keep track of that, but then person is 18, 19, 20, you can definitely, family can keep watch of the child and the adolescent. So should keep constantly, you have to give a counseling session to the child. Even if he's not there, you have to tell him this is bad. And this is how it starts the process. And eventually, if you go at a larger scale, government has so many schemes. Government has to, all those intelligence bureaus are finding out where it's a hub, or it's a small pockets where the drugs are found. Constantly there are raids, searches to try to do away with this. So government has a different plan, state government has a plan, central government has a plan. Apart from that, it is the family and the society who are more responsible, who has to give a right value. You have to guide right path to the children, and you have to keep watch on the children, what is activities, where he is going, how check his school bags, check his rooms at times, check his behaviors, and then do the corrective measures. This is how, probably this is what I feel can be done.
And of course, I feel that the schools also play a big role in such way, where where counseling also takes place, and you discuss them openly. You motivate people not to indulge into such activities. And I think it's a collective responsibility of the society as well.
Everyone put them into more constructive, constructive activities. Put them into sports, put them into plays, put them into dramas, more studies. These are the things you have to distract, put him, and so eventually those are the only corrective measures you can take to reform a person if they are involved into the
Of course. I am personally extremely fortunate to have been a part of this session, because I got some really good insights from about this case, I guess. And I think I'm sure that all the viewers have really enjoyed this session as well. Unfortunately, now with this, we have to come to the end of our session. Right. And I must say a big thank you to you, sir, and to Arif, sir, as well, for giving us their time and for agreeing to be a part of our very first webinar. I must say a big thank you to all our viewers as well, and the team of the United Forum for Legal Studies, because of whom I don't think this wouldn't have been possible. I would now request the founder of the UFLS, Mr. Shantu, to please say a few words.
Thank you, Sristi.
Thank you, sir. It was an honor. It was an honor, and I'm so glad that we got connected in such a virtual way. Thank you.
Thank you so much, Sristi, for your kind words. And Miss Speaker, because you really did a great job at International Conference of Justin Mutala Foundation. Moreover, we got 150 plus registrations through our website, and due to limited seats, people are now connected to us through our website and on Zoom. And we are really glad to have these two great speakers, Nitish sir and Arif sir. Due to some problem, Arif sir may not be able to continue, was not be able with us. And also on board with us in the board of UFLS, Nitish Rana sir and Arif sir, thank you so much. And furthermore, I want to thank my whole team who made this event a very successful one. And I request every one of you to please stay connected with us through our website and other social media handles. And e-certificate would be sent to you all soon. Thank you all for joining us, and making this event a very successful one. And with this note, I end this webinar. Thank you. Bye and be safe.
Thank you. Thank you, Shantam. Thank you, Sristi. Thank you to everybody. See
Thank
you
you, sir.
next
Thank
time.
you,
All
everyone.
right. Bye. Bye.